Hi everyone, I'm Dale Smith, aka Journo Dale, and we're here to talk about Canadian politics. All right, we're here with Carleton University's Philippe Lagassé. We had a lot of talk about the Emergencies Act in the last couple of weeks because of the federal court decision, which got me thinking about back in the early days of the pandemic when every single press conference that Justin Trudeau had, you had a reporter ask, "Are you going to invoke the Emergencies Act?" Every single day. And now that we've had it actually invoked, we had the public inquiry, we've had court challenges. Just what would that have looked like? I guess first of all, just in your estimation.
Well, I think the whole episode tells us something about a big gap that we have in our legislative framework when it comes to federal involvement in public order. As we'll get to when discussing the Emergencies Act itself, and as Justice Mosley kind of made clear, this is supposed to be a measure of last resort, and it needs to meet a particular threshold. When it was crafted and legislated, drafted, and all the rest of it, I think there was an assumption that provinces would not shirk in their duties from preserving public order and enforcing the law.
Hmm.
So this is one of these kind of unknown unknowns, right? That when you're putting
Yeah.
together legislation, you're not expecting it to reach that. And by the same token, as we saw, I think it's your opening comments kind of hits at the fact that there may not have been a good understanding about just how high the bar was for this thing. Um,
Yeah, and I think there was a lot of talk about, well, the provinces weren't acting fast enough or doing the right things in the pandemic, so the federal government should have stepped in and invoked it. There was even crazy ideas like they should invoke it to impose rent control nationally, weird things like that. I can't imagine seeing how any of these processes would have gone over around that one. But it's certainly was something that I guess captured the imaginations in the face of failures at the provincial level.
Yeah, and I think, in the early months at least, I think this notion that we were dealing with a national level emergency that couldn't be dealt with any particular jurisdiction. I mean, there might have actually been a better argument, for that than what ultimately turned out to be the case. Or at least let me change that and say maybe the courts actually would have been more open, right,
Mm.
to the argument that the pandemic itself met that threshold as a national level crisis, But there again, you would have had to demonstrate that the provinces couldn't do what they ultimately ended up doing, right?
Yeah.
And here again, I mean, it's just not meant to the legislation as it was drafted, and we can discuss amendments to it and changes and ways to improve it. But it wasn't really meant to deal with situations where provinces either don't agree or can't get their act together or whatever it is. It's really meant to deal with very high level problems that require a national response.
Yeah, and I think that's one of the lessons that I think we really are drawing from this particular exercise is that so much of our federal order is dependent on one level of government doing what they're supposed to be doing. And I don't know if it's just me, but it seems to me that we are increasingly finding a certain level of government in many cases are not doing the jobs that they're supposed to be doing. And that kind of really played itself out in this situation.
Right. I mean, the context that we have where effectively for political reasons, provinces know in some cases that they don't need to react or that they don't need to deal with the problem at hand, because if they just wait it out long enough, then somebody else will step in, right?
Yeah.
For somebody else being the federal government.
Yeah.
And as you're saying, I mean, we're seeing this across the board. And as you kind of point out, when it comes to certain parties in the House of Commons, there's also that expectation that somehow the federal government can come in and deal with the problem.
Definitely. Which brings us to the thing that I wanted to talk to you really about today is this piece that you wrote on your Substack about this crown prerogative of public order as a way of getting around the issue of a province who is not living up to their obligations in a situation like we had with the occupation in downtown Ottawa.
Yeah, so let me maybe give a little background to this. And it's funny, as since I've written
And I'm just before I do that, I'm just going to say I will link to the piece in the description below so that everyone can
Okay.
read it after. But go ahead.
Yeah, so it's funny. I've actually become more kind of determined about this view since I've written it. I think I was being too cautious when I wrote it. In speaking with some fairly interesting legal minds about it, they've kind of steeled me in terms of this. And in effect, I mean, what are we talking about here? We're talking about the fact that um, the Crown prerogative has always existed to be able to offer protection, right? Fundamentally, this is what the English courts told us in a case called Northumbria Police. And ultimately, what was that about? It was trying to reconcile, could the Home Secretary in the United Kingdom provide riot gear equipment to police without their explicit consent? And in going through this, the court ultimately said, look, there's something called the war prerogative, and it exists to protect the United Kingdom or the realms from invasion and to protect the population. And if you flip that around and you say, well, okay, if there must have been an equal power to deal with internal disturbances or internal threats to people and to peace,
Yeah.
right? And the very notion that we have in our own constitution of peace, order, and good government kind of hints at this, that this is a primary responsibility of governments. Now, you can have an argument. Where does that belong in the Constitution? Because typically when we have a prerogative, we tend to say, okay, well, we'll look at the distribution of legislative powers, and that'll tell us kind of where prerogatives go. Are they at the federal or provincial level?
Mm-hmm.
And as much as you can make a case that, as we see, emergencies and things like that should belong primarily at the provincial level, same with law enforcement or whatever it is.
Yeah.
We also have a federal government that does legislate for peace, order, and good government. I mean, it's like right in there in 91.
Yeah.
Right. So the idea that that prerogative wouldn't have existed or could never have existed in Canada is a bit odd. I mean, some people will argue that we didn't import it, but if you look at the Northumbria case, and if we accept that to be valid, which again, some people might disagree, but the fundamental notion that you would have a power at the federal level to deal with disturbances of public order that the provinces refuse to strikes me as a not illogical thing. And the very fact that the federal government was able to legislate the Emergencies Act tends to suggest that they must have had this ambit of authority, right?
Right.
Now, where it gets more interesting is that the Emergencies Act binds the Crown. Now, so on account of that, people would say, okay, even if that prerogative did exist, and there's going to be a number of people that are going to doubt that it did, has it now been displaced? So statute, when it binds the Crown, displaces the prerogative and occupies the same territory. And that's where in the Substack, I was saying, yeah, that's probably true. But the more I think about it, because I also had another kind of thought when I was writing the piece, and those of you, when you read it, you'll see it. The war prerogative hasn't been displaced by the Emergencies Act, even though the Emergencies Act permits war emergencies to be declared.
Right.
So we're kind of accepting when it comes to military deployment prerogative that there's lots of things that happen under the threshold of a national emergency, but the prerogative is still there. So if we just have that same thought about public order and we say, well, wait a minute. So if you can have the war prerogative still in place, in spite of the fact that the Emergencies Act legislates for war emergencies, then wouldn't you have the same thing when it comes to public order emergencies? What about things that are below the threshold, right?
There does seem to be a logic that flows there.
Yeah, and so you kind of say, does not, and then we take a step back and say, I mean, the whole purpose of prerogative and the reason that it's endured in certain places is because it's meant sometimes legislation doesn't get it right, or sometimes legislation leaves gaps that have to be filled by some kind of power. And here's a perfect example of unintended consequences where the drafters, as we said, kind of took it for granted that police would police and that provinces would ensure public order. They kind of took it as a given, right? You even have, and this is the other thing I hinted at, 8 of the civil power provisions in the National Defense Act. I mean, the provinces have lots of different things at their disposal to deal with this. What nobody could anticipate is if a province just not doing it or a city not doing it, right?
Yes.
And it's in cases like this where you say, are we really to believe that we have effectively nullified the ability of the federal level of government to provide peace, order, and good government through executive action. And as much as when I wrote the piece, I was like, yeah, well, we probably have, and that's a problem. Therefore, we should think of another solution.
Yeah.
Increasingly, I'm of the view that, well, you know what? I'm not, maybe this prerogative hasn't been displaced because of precisely issues like this. And people would ask, okay, well, what would that look like?
Hmm.
Well, we have a famous case around the prerogative, the war prerogative, I should say,
Yeah.
called the Kaiser's Royal Hotel. And what happens in the Kaiser's? So in the Kaiser's, the British government uses the war prerogative to requisition a hotel during the First World War. And that case goes up to the courts, and the courts say you could requisition property to fight the war, but you have to compensate the owner. Now, if the prerogative for public order is the sister prerogative, the other side of the war prerogative, could you not requisition tow trucks under that prerogative authority using the same logic into Kaiser? And then as long as you're compensating them,
Yeah.
saying, you people are using these trucks to do this. Because at the end of the day, if that was the fundamental thing, right?
Yes. And Leah West, your colleague at Carleton, has a whole thing about bugaboo about the tow trucks.
Yeah, so it's and as others have pointed out, there's in the Ontario legislation, there's a gap there of around the requisitioning of things.
Right.
And so, and this is why I've kind of wished I was a little bit more courageous in the piece, because the more I think about it, I'm saying, well, wait a minute. I mean, this is a fundamental question of state sovereignty and capacity, right? If the state cannot do what is necessary to deal with a major public order crisis that may not rise to the level of a national emergency, and that authority is very limited. I mean, there's a number of things that you wouldn't have been able to do under the prerogative, everything around the bank accounts and whatnot, but that's a good thing, right? Ultimately, maybe, maybe if that was, as Mosley found, a violation of the charter, then in a sense, that's the benefit of prerogative too, is it keeps your actions actually quite constrained to the very small little problem at hand, as opposed to trying to do too much, which is what happens when you get a more expansive legislative framework involved. Okay. So, I'm of the view at this point that, look, it's quite possible that that authority is there, and if it's not there, it probably should be, right? We should recognize it.
And is this something that we would need to recognize by way of statute, or would it simply be a government declaration that, yes, this power does exist and we hold it?
Well, unfortunately, you don't do that with prerogative, right? You don't come out and say, we have this prerogative. The way it typically works is that you do something and then it gets challenged and the government says this was prerogative, and the courts then decide whether or not that fell within the ambit of the prerogative. In this case, though, as you might imagine, if we were at the federal level to try and mimic the Public Order Act in the United Kingdom, that would be a very controversial piece of legislation, and rightly so. Because do we want, to start legislating in the space of further constraints on protest and things like that? Like, that could get very heated very quickly, right? Yeah. In a set, I think there's a number of people who would want to keep the threshold now of the Emergencies Act at the level that it is. And I think, as the Deputy Prime Minister kind of hinted at, now it's never going to, like, the likelihood that the outgoing National Security Advisor,
right? Jody Thomas.
She said, it's probably never going to have to be used again, because we now figure out that you can't just let these problems endure. Yeah. And while I agree with her that the likelihood is now far reduced, in the back of my mind, I'm like, well, what? I don't know. I don't know if provinces are going to be, willing, and it may not be an alt-right protest this time. There might be, would a left-wing government kind of be inclined to not act in the case of, an environmental group blocking major infrastructure? Who knows, right? Yeah. We just don't know. So I'm increasingly of the view that it's probably not wise to simply abandon what would have been a residual but very useful piece of common law power for the federal government in cases where you're really pushed to the brink, but it doesn't meet the threshold of the Emergencies Act.
Okay. it's yeah, I guess it's just one of these things to wrap your head around in terms of how we articulate it, or how a government would recognize it in that regard.
Well, and I think that's the challenge. The challenge is the time to do it would have been
Two
during the
years ago.
convoy, right? To come out and say, look, I mean, as far as we're concerned, this is just basic public order prerogative,
Yeah,
and this is the way that we're doing it. But it does tell us, and this is how I end the piece, just be careful when you legislate in this area
yeah,
because you're not quite sure, have you dotted all the T's and I's and crossed all the T's? Because there are inevitably things that you don't anticipate that are going to come up. And when you have legislation that is sets a very high bar and binds you in a very specific way, it's, you may be preventing yourself from acting in situations that don't quite meet the threshold. And I think this is where a lot of the public commentary has found itself. And the very fact that we have Justice Rouleau arriving at one conclusion, Mosley on another, is that this hints at the fact that there's something lacking in the act, and the way it's constructed is just not fit for purpose for things that just aren't that fall below that threshold where a
yeah,
province isn't willing to do something. And that's something that we shouldn't allow that to, as far as I'm concerned.
yeah, for sure. And given that we have some provinces now who are moving into much more open rebellion territory, I think that may find itself as something that we may have to think about sooner than later.
Yeah, and lest people think that what I'm talking about are draconian powers, let me be clear here. I mean, one of the beauties of a prerogative approach is that the prerogative is actually bound by all other law,
Yeah,
right? So it's not like there's a lot of things you couldn't violate charter rights with the prerogative. You wouldn't be able to do it.
yeah,
But you wouldn't be able to violate the Privacy Act with the prerogative. I mean, there's a number of things that you couldn't do with that power that you could do, as we saw with the Emergencies Act. And that's the other challenge is that if you try and kind of the minute that you kind of go in that direction, all the other options that are available in that statutory framework become very attractive. So
yeah.
we do want to come up with a very limited power to deal with a precise problem that no other clear solution has presented itself to.
All right. Well, thanks so much for talking this out and for explaining that. And everyone, go read the piece that's linked below. And thank you so much.
Thanks, Dale. Take care.
And that's everything for this week. Join us again next week for some more Canadian politics. I'm Dale Smith. It's at Journo_Dale on Twitter and JournoDale_no_ on Bluesky. And don't forget to like the video, share, subscribe, and support us on Patreon. Thanks, everyone.